Good afternoon. This is the March 15th meeting of the House Criminal Justice Subcommittee. We're going to talk about one or two, there's Delegate Bartlett. We're going to talk about one or two bills today. A pair from Delegate Pippy, 185 and 471. And if we have time, we'll do a quick chat on House Bill 1053 from Delegate Williams. But why don't we go ahead and bring in any of the folks who are interested in the two Pippy bills into the room. And I'll let those folks trickle in. All right, it looks like the folks who are interested in the Pippy bills are in the room. So I just want to, for the benefit of the committee and the folks who are here on these two Pippy bills, and folks, please mute yourselves if you can. I had a chance to talk to Delegate Pippy, and he's got two bills. House Bill 185 was visual surveillance with prurient intent with a minor victim. And the other one, 471, was indecent exposure with lascivious or prurient intent. And having spoken to the sponsor, I think we're both hopefully comfortable with what we did on Crosby's bill. We upped the penalty on indecent exposure for in front of minors. Pippy's bill had some additional penalty enhancements, felonizing it, and some registry questions. But I think for now, we'll stick with the Crosby bill on that, and then try and focus on House Bill 185, which was a similar but different topic. This was not about exposing yourself in front of a minor. This is about spying on a minor. And so the bill came in with, 185 came in with some penalty enhancements it was seeking. And we can put a pin in that for a second, because my eye was attracted to one issue that I thought might be a little bit of a quicker, easier consensus lift. So I just want to introduce this other topic for discussion. And it actually came in by way of a Lisa Jordan MCASA amendment, and it has to do with whether this section of code dealing with basically peeping on or planting cameras to peep on people, whether it, if you look at page 2 of House Bill 185, it has a series of definitions for what a private place is where these offenses may not occur. And it goes on to talk about a business, an office, a store, a rec facility, hotel, motel, restaurant, theater, school, bank, any part of a family child care home used for the care and custody of a child, another place of public use or accommodation, and then private place, and then it clarifies that that includes a tanning room, a dressing room, a bedroom, or a restroom. And I guess there was some question as to whether surveilling someone in a private residence would count here. So if I may, I'm going to ask Lisa Jordan to clarify, I guess, the intention of this request.
Yes, thank you, Mr. Chair. Lisa Jordan from the Maryland Coalition Against Sexual Assault. And so the request is just to clarify that the prurient surveillance may not be in a private residence. And the example I provided in your email say you have a meet and greet, it's at a private home, someone places a camera in the bathroom and is taking pictures of your guests' private areas. As the law is drafted right now, that's not a place of public use or accommodation. It doesn't fall under that list of 1 through 9 that the chair just enumerated. And I recollect when this was passed, it really was considered a public place. And this is not just an issue with the judge's case, which of course took place at a private hunting lodge. So that might not have been prosecutable under the current law, but we've also seen it in other cases where, someone had photographs of their genitalia in a private home, by a stranger, but still in a private home. And so the amendment proposed, with which Delegate Pippi did request and is attached, would add a residence, and then it would clarify another place of private or public use or accommodation. I just don't think that the penalty and the prohibition on visual surveillance with prurient intent should matter, whether you're in a private home versus a public place.
Joe Riley's hand is up. Do you have a response on this one also?
Can you hear me with my headphones on? Okay. So the intent of this bill was not to make anything that isn't a crime already a crime. I appreciate the clarification, Bill. I think it's necessary. I think it's welcomed. But I think if you talk to the prosecutors on this bill, we're already doing these types of prosecutions that Ms. Jordan's amendment is addressing successfully already. Now, I'm not saying that it's not warranted and it wouldn't clarify, because it certainly would clarify, but the intent of this bill wasn't to make something that is currently legal not illegal, is my understanding of the bill. It was simply to find the appropriate sentence for this action and find appropriate justice for the victims of this crime.
Yes, the sponsor, Delegate Pippi.
Thank you, Mr. Chair. So the way I see it now is there's 2 parts to my bill at this point. There's the part that we're discussing, which is the clarifying language to ensure that in cases of prurient intent and surveillance are also accounted for in private places, and that's fine. And then the second part, which I'm assuming we're going to get to, deals with minors, because the prurient intent in private residence doesn't distinguish between adults and minors. And so that was the bigger issue for at least the prosecutors, was ensuring that, when minors are surveilled, whether that's in public or private, that there's some accountability there. And so I'm hoping we can at least get to that. But just to Joe Riley's point and Lisa Jordan's point, there's 2 parts to the bill. I think they're both important. But I hope we can find some common ground on both issues.
All right, Delegate Erican.
Yeah, sorry, I meant to put my hand back down. I was just going to ask if Delegate Pippi wanted to chime in.
Okay. Well, sorry. So I'm having trouble understanding here. So can we just clarify? Do we believe or do we not believe there's some ambiguity as to whether the private residence issue could impede enforcement here? Yeah, Mr. Riley, go ahead.
The amendment would certainly clear up any ambiguity. It would certainly do that. But from real world practice in our courtrooms today, I'm not seeing the problem that Ms. Jordan is diagnosing here, but it certainly does clear up any ambiguity.
Lisa Jordan.
Thank you, Mr. Chair. I certainly respect the prosecutors on the phone, and I'm aware that there have been some cases that prosecuted the private places, but I've also seen some cases where the prosecutor declined to go forward because of it, and I'm unaware of any appellate decision on it. I did discuss this with committee counsel in JPR, and he shared my concern that if it went up on appeal, that this could be a problem just under the plain language of the law. So from MCASA's view, although we certainly appreciate all of the good work the prosecutors are doing and fighting to push the law as far as possible, we are concerned that it's not clear and would hate to see a survivor go through a trial only to have an appellate court overturn a conviction. And I would respectfully suggest that none of you think it should be okay to do visual surveillance in a private residence. So again, would just ask that you consider Delegate Pippi's amendment on this aspect. Certainly that's not to say that we don't also support some sort of increase in the penalty for children, when they are surveilled. And I know that the bill came in with 10 years and a felony, but I believe that perhaps even just raising it to as much as you got in the indecent exposure bill, maybe 5 years, would at least be appropriate when you do have someone who is pushing on surveilling children. That being said, we still really firmly believe that the first part of the amendment, changing it to a residence or private place, is really important.
And I'll just, Mr. Chair,
Yeah, go ahead.
I'll just say, I think part A, which is what at least Jordan just discussed, I think is important to do. And as the sponsor, I'd like to at least move forward with part A to clarify that language to ensure that someone doesn't get off on a technicality. And then when you're ready, I'd like to just at least bring up part B and why I think it's important to address them if this deals with the minor. And what we currently have on the books, once I tell you what the penalties are for even in the case of a minor, it's somewhat shocking.
Okay. Yeah, Delegate Bartlett.
Okay, so I want to make sure I understand. Do we currently not have anything on the books for video surveillance in a private residence? Is that what I'm hearing? That doesn't exist now?
Pretty much.
Okay, well then it needs to, in my opinion.
And I think let me ask counsel to chime in here. I think Claire might have.
Yeah, I
thing.
just wanted to point out, and I'm not saying that that Ms. Jordan's request is not good, but I just wanted to point out, and maybe the prosecutors can discuss this a little bit more. The very next statute in the criminal law, Article 3903, deals with private property. Now there are several exceptions, but then the main prohibition reads, a person may not place or procure another to place a camera on real property where a private residence is located to conduct deliberate, surreptitious observation of an individual inside the private residence. And it's the same penalty as under 3902. Now, I don't know if a hunting lodge would be considered a private residence.
Interesting. Okay, well, it
can I
doesn't
ask
sound
another
harmful
question,
in that
Mr.
regard, right?
Can I ask another question, Mr. Chair?
Oh, yeah, go ahead.
So my concern is, where was it, the bill? My concern is that when we use things like camera or we use actual technology, it's not broad enough because the technology is way faster than we are, and that's a big problem to me. I'd rather have the place. I mean, we kind of know where, private homes are. That's not changing so rapidly as technology. So I'd like to have it broad to say, to include the place.
In both statutes, 3902 and 3903, it defines camera to mean that it includes any electronic device that can surreptitiously to observe an individual. Those statutes say that at the beginning to address your point.
Yeah, okay, but I still like it. I still like it.
Oh, yeah, I mean, I think, from where I sit, it doesn't seem harmful if there's if a hunting lodge somehow might squeak in in the cracks here. But why don't we do this? We don't have to vote the bill, and we don't have to vote any part of the bill, but can we at least get a raise of hands on adopting in this language on private place, on the on 3902?
This is the private place.
Yeah, Janine,
Amendment.
can we put the language up? Can we put the language up on the screen for what this proposed amendment? And Jeannie, if you don't have it,
I believe I have it.
it's pretty simple.
Yeah. Move the amendment.
Second.
Delegate Davis.
Mr. Chair, I don't think it's so simple. With the advent of Ring cameras all through my house, is the burden on me to prove that I didn't have prurient intent? Or if I record something of somebody else doing something in my house, is there prurient intent? I can't support it. Thank you.
Maybe the state's burden.
There's a series of exclusions too. It doesn't apply without prurient intent. Individual, the Ring, I think this is on line 25 on page 2. It talks about an exclusion for protecting your property, the visual surveillance to protect property or public safety. I think that's meant for alarm systems. Delegate Fisher, you have a.
Sorry, I have different nails on, so it's hard for me to get to the unmute. I just wanted to go back from our meeting either yesterday or 2 days ago with the difference between prudent and what's that other word, Shoemaker?
Lascivious.
Yeah, I wanted to just be on the same page with that.
They come out of
I'm
federal
fine with
law,
the
apparently. They come out of federal law. I mean, yeah,
You
Pippi,
need both or you don't need both?
I don't think you do, but Pippi, you want to address that since you're on here?
That's what confused me, Delegate Pippi, last time we met.
Sure. I mean, they more or less mean similar things.
Yeah.
It's just, for example, when we did the pornography bill in 2019 as a committee, we just used the federal terms, and those are the terms that are most recognized to identify the difference between someone taking a picture for some horrifically sexual things versus someone accidentally taking a picture of their own kids in a bathtub, so to speak. And so that was really how you identify the difference between something that's a crime and something that is, I don't know. When I was naked in a bathtub, and for my parents, that wasn't lascivious or
Right. And let me ask, maybe it's for Lisa or for State's Attorney Riley, the difference between this and I guess pornography is, there's one that's considered an art form, obviously with children. Or hi, Joyce, I didn't see you there. Joyce can probably answer it for me too. Can you guys just delineate the differences between all of those kind of acts?
Joyce has her hand up. I don't know if you were trying to.
Yeah.
I think she was trying to answer me. Thank you, Joyce.
I was going to distinguish the lascivious and prurient. I know that there was questions both in JPR regarding that too, and I spoke with counsel there. And Delegate Pippi, did a good job kind of doing it succinctly, but basically one of the primary questions with regards to lascivious is whether the depiction is intended to elicit a sexual response in the viewer. So it's about arousal. And it's not just, I think there was another question that if I am surveilling my teenagers to make sure they're not having sex, that is an interest in sex, but that's not what we're talking about here. We're talking about a sexual arousal for your sexual responsiveness to what you're watching is how the courts have distinguished it. And to Delegate Fisher, what you were talking about, I testified as to this previously, we in these situations where individuals are installing cameras into shower stalls or bathrooms, federally, we have charged this as production of child pornography because it is the lascivious display of children's genitals. There was a bad DC Circuit case that came out that said that that was no longer, they did not find that to be production of child pornography, which is why we're trying to fill the gap here in Maryland to make sure that there isn't this gap in the law in criminality. Because for me, in the cases that I do, this is one and the same as production of child pornography that I often see, this type of visual surveillance.
Right. And that's why I'm confused. I'm like, why can't you charge them under child pornography and move on?
We have in the past, unfortunately, because of, some courts are beginning to distinguish the difference because of the nuances of where the camera is placed and what was the purpose. I know that Mr. Riley's case with the judge was one of those borderline cases where I think the federal authorities were hesitant to, or the local authorities rather, were hesitant to charge production. So it depends on what jurisdiction and how aggressive law enforcement or comfortable law enforcement feels in proceeding that way. So I think that marrying up the penalties for the same conduct in the statutes would obviously fix that.
And you're saying right now, the felony, the 10 years and the $5,000 is the same for child pornography, or their level?
Yes, that's the production of child pornography. It's
the same punishment. Okay. Thank you for that help.
So I hate to be raising questions because, I find some of this logic persuasive, but here's one of the reasons I wanted to end on the penalties and not start on that question was because there's one complication I'm hoping someone might address. The existing offense is not necessarily about recording and creating video. It also, I think this one includes just direct observation, doesn't it? Visual survey, direct sight. If you look at page 2, line 18, it's visual surveillance using mirrors, cameras, or direct sight. And so I guess if we apply a child porn production penalty to it, it seems like number 3 would fall in that category, but number 1 or 2 might not. And so that was my first thought about that is if we did want to mess with the penalties, would we need to sort of break that up in some way? Does anyone have any comments on that?
I'll make a comment. I mean, the issue is that currently visual surveillance has a maximum, misdemeanor fine, even in cases of children, and it's 1 year, $2,500. Child pornography, as just discussed, is a felony. So I know that the committee is not terribly fond of felony crimes in general or adding more felonies to the books.
Well, let me rephrase. Would it be fair to say your penalty provision on page 3 is actually meant to apply specifically to page 2, line 20, 623 of that section?
Yeah, that's fair to say. I don't know what the penalties are for watching child porn. I mean, but
I don't know either. But I guess as to this 10-year felony that you're requesting, it seems to me that it's really getting at that one part of the existing offense, unless I'm missing something.
Yeah, because I think the production of child pornography is different from the possession of child pornography. Joyce could probably chime in on that, but yeah, that's probably fair to say.
That's correct. Yeah, possession of child pornography is a 5-year offense.
Is it a felony?
No, it's a misdemeanor.
Okay. So there might be something there, Mr. Chair.
Well, that's the conversation then that I was trying to steer us to. is that the bill is drafted, in my opinion, is a little overbroad for the penalty it's seeking. And to the extent there was a question about this hunting cabin involving the judge, could we get a quick consensus on just doing that if folks wanted to do it? And if we wanted to do that, then let's have this other conversation about whether folks did want to look at the penalty enhancements. And again, if we were going to head there, I just wanted to flag this issue that it seems to mix both child porn like stuff and non-child porn like stuff. So I throw that up for discussion. Delegate Bartlett.
Just want to make sure I understand. Okay, so so what you're saying on the section about the direct site and the use of mirrors, were you saying that that should have a lower penalty than the use of cameras?
I'm saying they're trying to bring in a child porn production penalty into sneaking a camera into a private place, but not all of the things they're applying that 10-year felony to actually seem to fall in the category of child porn production, but some of them do. I'm not suggesting we do anything. I'm just pointing out I'm just pointing out this aspect of the language we're looking at.
Okay, but what I'm saying is I want to make sure I hear you. On the child porn stuff, all right, what can you just distinguish the two? What is
that if you're using a camera, it seems to me you're producing pornography.
Okay. All right.
But if you're seeing it with your own eyes, I don't think you could be argued to be producing child pornography.
Okay, thank you.
Joe Riley.
So the scenario for mirrors most commonly is what's known as upskirting. You have a mirror on a shoe. You put your shoe in a position that you can view of someone's skirts, and that would be the use of mirrors. It's the most typical one. It's not the only one. Whereas the cameras would be different. So if you think that they should have different penalties, that's up to you. But that's the typical nature. It doesn't seem to be much different to me, but I understand that you might feel differently.
Delegate Bartlett.
So one more question. So this is obviously not an area that I know a lot about, but I'm just reading in the paper. It seems like there used to be, I don't hear about it as much, but there used to be a time in dressing rooms and changing, that folks had a mirror. They weren't necessarily recording it, but there was a two-way mirror because they were using it for security and all that. I think that law might have changed where retailers are not allowed to do that anymore. I can't remember, but in a circumstance like that, and if they did it, more than once, I don't care that they didn't have a camera. That doesn't bother me that they didn't have a camera. The fact that they're spying on people undressing is the part I have the problem with. So anyway, there's my thoughts on that.
Delegate Pippi, final thoughts?
Now I know some people, I'll let that go.
Delegate Erican.
So just so I understand what you're suggesting, Mr. Chair, that we pull out the pieces for mirrors and visual and separate that and put that under what penalty structure? And then your idea is to put the video recording under the child porn statute, which right now is already a felony?
I was just going to suggest we fix the private hunting cabin issue and get out of town quickly. Now,
cute.
if folks, however, want to visit the penalty section, I mean, whatever, it's up to you guys. I'm just suggesting, to me personally, I don't know if I support applying the child porn higher penalties to things that aren't child porn. But I do see some child porn in what this bill is requesting. So, but again, we can do whatever you guys want to do. I was just merely flagging that the hunting cabin thing might be something we could all get around, but
Yeah, I think we all support the hunting cabin. I think some of us, probably Delegate Shoemaker and Delegate Bartlett and I would like to see, I think a little bit more, just judging from the comments, around the penalty side, because like we've said before in this committee, these are escalating crimes. So we are starting out with people who are doing these smaller things, but these crimes graduate when the people are not appropriately penalized for them. And so what's right now is upskirting. In a couple of years of getting away with that and getting a slap on the wrist could become something absolutely atrocious. So, I know for a couple of us, I think we're willing to work on the penalty section. And I don't think it would take a lot of time or brain power to accomplish that right now. If you were willing to do that with us, I think Claire could probably draft us a good amendment, but I'll defer to Delegate Pippy if he'd like to weigh in again on his bill.
Can I, Mr. Chair?
go ahead.
All right, so I'm definitely open. At the end of the day, it's your the fate is up to the committee. So, Joyce, what was the penalty for watching child pornography? It's not a felony. What is it?
It's a possession of child pornography is a 5-year misdemeanor.
Okay. So, to move this along, and I don't want to shoot myself in the foot, but I would be open, if it helps the committee, to, because there is a difference, in my opinion, there could be a difference between direct sight and use of cameras. And the reason is, with cameras, you can share it, right? So when you take a video, when you take pictures, you can share it. That re-victimizes the victim over and over and over, versus if they saw something themselves, it's just in their own head. If the committee would be open only in cases of minors. So if there's visual surveillance of a minor, whether that's in public or in private, because we'll fix the private side, that we go to an enhanced penalty of like 5 years, whatever, similar to Crosby's bill and similar to what the current crime would be if you were caught with child pornography in your possession. And I think
that's a reasonable compromise, it sounds.
And it's for minors only. So, this committee has protected children quite extensively for a long period of time. That's my concern. I'm grateful we're taking care of the private thing. That's fine. That's a textual amendment. But really, there's a big loophole with minors in visual surveillance where somebody can put a camera in a strategic place, get compromising photos of children, and now it's a small misdemeanor is what that is. And so we'll keep it that misdemeanor, but at least we can offer an enhancement. So if the chair is okay with that, that's a pretty healthy compromise. It's not a felony.
Yeah.
Same penalties as Crosby's bill, and it's the same penalty as if you were caught with child pornography on your possession.
Move favorable on those amendments, Mr. Chair.
Second.
Let's have some discussion on this amendment. The proposal is to take the 5 years, to take a 5-year penalty on all of the offenses in this bill, right?
Yeah.
If it's involving the minor with the 4-year age gap and all that business. Delegate Anderson, you have your hand up.
I did have my hand up. And look, I have no problem with the bill. The only concern I do have is that, I think I've raised it once before on Crosby's bill, is that, are we seeking just to punish the person who changes behavior, or are we trying to come up with a way to change behavior so this doesn't happen to children again? That, yeah, you can punish the person, but if he's sick, if this is a sickness, or if he needs some kind of mental health treatment or some kind of counseling, we're not helping at all. We're just, giving him a bigger penalty and putting him in jail longer if the judge so sees fit. But shouldn't we try to be addressing the main problem? A person does this is sick, I think. And yeah, you can punish him, but does that get rid of his health, his mental health problem? and I'm good with the bill. Okay, I'll go along with it. But in addition to enhancing the penalty, should we not try to give some kind of alternative to help cure the person, to keep it from happening again?
Can I reply back?
Hold on, we got Delegate Bartlett next.
So I think that the judge always has the discretion for the mental health counseling. I appreciate what you're saying, Delegate Anderson. I also think that I had a question about if we change it to 5 years, what is the fine, the fine, the penalty? Because it was 5,000, is it going to be what? 2,000, 2,500?
No, I mean, HB 34 is 10,000. Joyce, do you know what the fine is for?
It's 2,500
Oh, is it?
off the top of my head, yeah.
Ta-da.
I mean,
Okay,
I'm not
thanks.
hung up on the fine. I'll be honest with you. So
Okay,
I'll leave that
thanks.
to the will of the committee. If it helps to keep it at 2,500, leave it at 2,500. If it helps Anderton to make it 10,000, then, move it to 10,000.
Delegate Erican and then Fisher.
Thanks. Just in reply back to, I know Delegate Anderson's been worried about treatment and stuff like that, which, judges already have the opportunity to offer that. I will say we had a great tour set up by our former vice chair. We went to Howard County. Many of you were there and remember that. And this question was asked to the prosecutors, which you may know the prosecutor's office there is not run by my party. I asked specifically, what does it look like for someone who is charged with sex crimes for recovery? How many people would you say recover in the therapies that are provided? And they could not think of a single person, a single case, no matter how much therapy the person was offered, that helped these people stop doing these behaviors. So I just want to make sure that when we're talking about sex crimes, it is not like many other types of crimes, crimes of opportunity or crimes that are based off of a lack of resources. These crimes are different. They are different. The motives are different. And curing people of wanting to sexually abuse children is really a kind of a pie in the sky wish. So I think my focus, at least on this subcommittee and our committee, is to make sure we kind of accept that the reality of the situation is most of these people are not cured. We have to protect the children because it is very, very, very hard with the research and the therapies that we have today to cure people from their desire to sexually abuse children. So just wanted to make sure we were all on the same page.
Hold on. Let's go to Delegate Fisher next.
I don't know what to say after that, other than I just wanted to see, I need to visually see, Mr. Chair, how we're amending the bill or a delineated, I'm sorry, my words are kind of caught today, a delineated version of the bill to go forward on a vote. So I wanted to put that out there. And I will say, Delegate Erican, I understand your points, but I also, I've known Delegate Anderson for a long time, and I happen to be randomly student body president of Penn State during Sandusky. So all I did my 3L year was deal with that case, my university, and sexual behavior. And I will tell you, Penn State put money into actual graduate research into it, because if you keep ignoring it, I'm sorry, the human existence has been abusing children from the beginning, right? Men using young boys as a way to learn about sexual, it's been part of human existence forever. And so until I think our society and greater resources really want to dive in deep so that people aren't just traumatized and punished, but actually I understand what Delegate Anderson's saying. I do think it's an entirely separate bill that I would like to see to have requirements for all people and all folks that do sexual crimes. But I do respect what he's saying, and I do think that you get what you pay for if you don't put any research or anything, and we're just willing to just say everyone's soul is unrecoverable. I don't believe in that, but I do think I do think it is a different bill, and I wonder if Claire can take what was orally offered to the committee from Delegate Pippi and write it out.
Hang on a second there. let me take one more try at this. Because I'm not trying to hang on to these bills for too long, to be perfectly honest. We're heading into crossover. What if we went back to my idea about page 2, line 20, and put the 5-year misdemeanor on that? Fixed the cabin problem and left town.
And then left it off direct site and use of mirrors?
Yeah. Again, if we're trying to close the gap that was created in child pornography production, you know, I think going to page 2, line 20, to me is the target section. And it seems to be some squeamishness about just straight penalty enhancements on the full category.
Because they would still be held for the other two under 1 year, 2,500, looks like. Yeah, I mean, well, I'm not a voter, so.
Mr. Chair, I have a bill in HGO, like next.
All right.
Delegate Moon.
Yes.
Can I just,
Favorable. Move
can I
favorable
just
movement.
clarify, please? Can I clarify what you're
Yes.
proposing?
Yes.
So are you proposing to say, to change it to on page 2 in line 17, a person who violates this section by use of a camera is guilty of a misdemeanor and on conviction is subject to imprisonment not exceeding 5 years or a fine of $2,500 or both if, and then keep the rest the same? Is that your proposal?
Yeah, that if as to visual surveillance by use of camera where the victim was a minor at the time of offense and the perpetrator was 4 years older, that you're basically going to get a 5-year penalty instead of the normal penalty because you're making child pornography.
Yep, I'm good with that.
And we would fix the cabin issue.
Yep.
Move favorable.
Second.
Is there any discussion on this attempt? I want to, Delegate Bartlett, quickly, please. We want to get folks out of here, I guess.
Yeah, I was going to ask 2 questions. I'll make a comment and a question. Comment, if I'm not happy with it, I'll just change it, you know, if I need to next year. And then the other thing was on the question, are you calling for a vote, Mr. Chair, with the motion?
I just want to quickly get a gut check on this, but if we're good, then I'd like to call a vote.
Yeah, I mean, I think I could vote on it. I don't know about everybody else, but I think I could vote on it.
Delegates Davis, Anderson, or Fisher, or are you guys good to vote on this? You don't have to vote for it. It's really just, is this a reasonable way to put some closure on this one? We would just put the penalty enhancement on using cameras to tape children in private places.
But let's go vote.
All right. Well, then I would like to move in principle that we fix the hunting cabin issue with the portion of the Pippi and Casa amendment, and then stick a 5-year misdemeanor on the use of cameras to visually surveil a minor under 4 years younger than the perpetrator. Is there a second?
Second.
All right, all in favor of that amendment in principle, raise your hand. Anyone opposed? All right, Delegate Davis opposed. All right.
Mr. Chair,
knocks that-
quickly, did you
Yes.
put in the private? Did you put in the private resident? Oh, you did
Yes.
say that? Okay, I
Yes.
must have missed it. Okay, thank you.
All right, thank you. Delegate
Did you-
Pippi, I'll look for your withdrawal slip on the other one.
And you're adding me to Crosby's bill, right? That was the deal?
No, there's no deals here. We can make the request
This
to
is
the chair.
Annapolis. It's all deals.
Well, the adding sponsors is really at the chair's.
I'm texting Luke right now.
Okay.
don't think we're adding you to Crosby's bill.
All right. I miss
All
you
right,
guys.
thank you,
See
everybody.
ya.
Thank you all.
What time is it?
So,
What time is the voting session?
well, no,
4:30.
you guys, we have one more. The voting session is going to be at 4:30. I'm
Right.
sorry, we have one more just for a quick discussion. We can bring in Delegate Williams and friends for House Bill 1053.
Great, Bill.
Hello.
All right, hi, everybody. We are back on House Bill 1053 from Delegate Williams and Shoemaker. This is a bill to require phone operators, essentially cell phone companies, to release location information under exigent circumstances. I had some questions, to be honest, so I don't know how far we'll get today. And I'll just, we had a brief discussion last week on this, and we were trying to recall the genesis of the bill, why it's necessary, really the basics. And I was drawn to one part of the fiscal note where it says, it seems to imply the problem is theoretical and that the law enforcement hasn't actually been denied a request when someone's life has been in jeopardy. So I guess we're here to just be reminded of the bill.
Right. Yeah, so this bill, as I stated in the testimony, is based off of legislation that's been passed in 36 other states. The Kelsey Smith Act, I guess the genesis, the parents of Kelsey Smith had reached out to a couple of folks, myself and Delegate Shoemaker, about this bill. They're seeking to get it enacted here in Maryland. And so one of the things that we're seeking to do is really just try to make, I guess, a more streamlined process for when these types of instances occur, to allow law enforcement officer to be able to ping a cell phone to try to locate the missing person as quickly as possible. I see Chief Morris on here from the town of Riverdale Park. Good to see you, Chief. And so, I'm sure Chief Morris can probably talk about how when we do have these missing persons case, how time is really of the essence in these particular situations, to try to locate the person as quickly as possible. And so that's really what this bill is seeking to do. There were some amendments that were sent to the committee back on March the 3rd, which hopefully all of you guys have to kind of address some of the concerns that were raised by some of the advocates on this bill. I believe, the cross-file on this bill is Senator Bailey on the Senate side. And I don't know if it's been voted out of JPR just yet, but I think it's on the voting list to be voted out of JPR either today or tomorrow. And so that's kind of where we're at with this bill.
Can you explain what the JPR amendment does?
Yeah, and the amendments I sent to the committee, I think, are the exact same ones that were provided to JPR. Let me pull up that email here really quickly. Give me 1 second, Mr. Chair. So the first amendment deals with some concerns that were raised by the cell carriers, AT&T, Verizon, et cetera. Just to, they wanted to replace, basically states that, that this that the cell phone carrier directly or any of their employees would not be personally liable for providing this information over to law enforcement in furtherance of what they're requesting and what they're seeking to do. I'm looking at the First Amendment, so it just simply inserts, that this section applies only to a request for location information of an electronic device if the owner, and this is the Second Amendment, sorry, the owner or user of the electronic device is believed to be missing, or there's probable cause to believe that the owner or user of the electronic device is committed or is about to commit a crime of violence as defined in section 14-104 of the criminal law article. And that last portion there is consistent with other sections in the criminal law article that relates to the use of electronic device in terms of obtaining information from electronic devices. And so that language is consistent with other sections in the code. Oops,
And just for everyone's clarity, yeah, sorry, just for everyone's clarity, we're going to probably wrap at 4:15. So we'll just do a very quick discussion on this. Delegate Erican.
Thanks. I haven't seen the amendments, so I was looking through my email. I didn't see them in there, but I would love to look at them. I'm a little just worried about domestic violence victims. So is there an opt-out? I mean, is there a way for someone to say, I never want this to be used to track me? You know what I mean? Like, how could I say if I didn't want anyone to find me, how could I make sure that that is possible? Because people sometimes run and they don't want to be found.
Understood. You know, I think I don't really have a very clear answer to that question right now, Delegate Erican. I mean, as stated in the language that I mentioned, the police have to have some type of either probable cause or, you know, usually these things start when a missing persons report has been filed with law enforcement is usually the impetus in which this began. So if someone ran, you know, for their life, I mean, they're running, like I said, unless a missing persons report was filed, I don't think that would even trigger an investigation to this vein. Let me pull the full bill up. Give me 1 second.
Yeah, because I mean, if you had a spouse who was, you know, coercive, controlling, etc., abusive, and didn't want his wife to leave, and she left, he could easily file a missing persons report, and then he wouldn't even have to go find her because the police would be able to find her for him. And you know, that is a little bit scary for me, just knowing friends who have had to run. I mean, I wouldn't want somebody like that to be able to just look to the police and say, you know, get my wife's cell phone data and let's find her.
Well,
because
it's not the, yeah, well, it's not the data. Like I said, it's just the pinging, the location of the phone.
Right. Yeah. Yeah.
That's really all that's being found. And there aren't any, isn't any information in terms of phone logs or anything like that. And then there's also provision in the bill that the person who owns the device will also be notified that their location has been disseminated. So if in your scenario, the woman was the owner of the cell phone, then she would be notified that there's been a request for her location information.
Like on her
from
bill?
cell phone carrier. Yeah.
Like on the bill, or would there be like a real time like ping that says like you're being tracked right now? Like how soon would she know that now potentially her ex-partner who she's running from is gonna know she still has this device, she's still using it, and the police now know her location? How quickly will she know that?
Right. In the bill, I believe it doesn't give a specific time frame. It just states that they will be informed. Trying to find the actual line here to make sure I'm getting you the exact language here.
David Morris has his hand up, maybe wants to provide some insight into some of this operations. And again, we just got a couple minutes left, so go ahead.
Yeah, good afternoon, Delegate and Delegate Williams. It's always good to see all of you, and I look forward to seeing you more in person, Delegate Eric, and I can appreciate your concern. That would be a concern equally important for law enforcement. And I think that goes to the investigation and the purposes behind this. I'm mindful of the reason for this bill, and in particular, the young lady named after her, Kelsey Smith, who was murdered when she was about 18 years old. Congress has taken this bill up. And I will say this, that historically law enforcement has had a cooperative relationship with the carriers. I think that's important to note. The carriers recognize that seconds count, minutes count, particularly when we're trying to locate someone whose life may be in jeopardy. So that's really the genesis of this bill, and equally important to be able to give immunity from any civil liability to the companies, and as Delegate Williams has mentioned, to the individual immunity as well. Because as you know, there's turnover and everything, and someone who might be working that phone or that emergency contact mechanism at 2 o'clock in the morning may not be as familiar with the policies and protocols, and that can slow things down. And at the end of the day, this really is about trying to locate people and save lives. To address your concern, I think what I would say from 36 years in law enforcement is we get the need, particularly in domestic violence cases. And I will tell you that I'm particularly sensitive to that because I've seen a lot of it in my years. And I think that all goes to the investigation. So I think the answer to that is that as we work through this and we recognize why is it we're trying to locate the person, and if law enforcement doesn't feel comfortable with those responses, and typically there is history, particularly as it relates to domestic violence, and we can curtail that that search or use it in such a way to make sure that the individual is okay and that they don't need police assistance or intervention while out without compromising their location if they're fearful for their safety. So there's no definitive response. It's commensurate with the level of the investigation.
And could we just and could we have maybe Elizabeth Hilliard, since you're the opposition on this, if you had to give us food for thought why you opposed it, you've got like 2 minutes to just sort of help inform our
and
discussion
Mr. Chair,
on this.
I was just going to answer Delegate
go
Eric
ahead.
Hand's. So sure, it just says reasonable amount of time in the bill is what it says, Delegate Eric Hand.
Great.
Just briefly, I did not receive a copy of the amendment, so it does sound like some of them do assuage some of our concerns. Largely, our concerns as an office were just the overbreadth of the sort of scope of the statute. It didn't contain a lot of limiting language, like the example Delegate Erickson is bringing up, or other circumstances in which we understand, especially tailoring it to the person who there is a belief that they're in danger or harm, like alleviates a lot of the concern. But the definition of exigent circumstances is just really broad, and my understanding is maybe there was also an amendment to propose a subsequent judicial review after the fact. That's one of the proposals that we had mentioned in our written testimony, is to sort of create a back end review process just to sort of ensure that there were no abuses being made of this sort of like broad power. So we were just concerned about the scope of it, basically. I did look at all the other states that have imposed this law. There have been some states that have narrowed it a little bit more, and that's sort of what, and the ACLU in a lot of states has gotten involved in aiding in the narrowing of it, and that's sort of what our concerns were and what our positions were. So I'd be happy to take a look at the amendments. And
yeah, I'll forward you the amendments, Ms. Hilliard. I apologize you didn't get those. With regard, and we took up some of the concerns, the judicial review piece. When I went through, my office went through all 36 of the other bills that have passed, and none of those included the provision as it related to judicial review. And so that's not part of the amendments that are before this committee, just based on the precedent from all of the other states that have enacted this legislation.
All right. That was a very quick and dirty discussion on this one. But if you all could do me a favor, then share the amendments, continue the discussion offline, and see if you could get any closer. And then maybe we can take this back up when we reconvene. All right. Thank you, everybody.
Great.
That's the end of the Criminal Law Subcommittee. See you for voting at 4:30.